Good morning once again, and you're still watching Sunrise at Sea here on CTV. Welcome to Twitter Jabs. My name is Agi Uwase, and we are continuing the conversation in regard to the bid of freedom, or you can actually call it bid to freedom. And we are more specifically talking about the case of the Makinde West Member of Parliament, and that is Honorable Alan Ssewanyana, as well as the Kawempe North Member of Parliament, Honorable Mohammed Ssegirinya, who have been behind bars since September last year. And on Wednesday this week, the Court of Appeal once again denied them bail. Now, joining me today to give us an insight in regard to this case is a human rights lawyer, and that is Counsel Jude Byamukama. Now, Counsel Jude Byamukama is a Ugandan-trained attorney and advocate. He is a frequent practitioner before the appellate courts, especially the Court of Appeal and the Supreme Court of Uganda. Good morning, Counsel, and thank you so much for joining us.
Good morning, Ines. Thank you for inviting me.
Well, you're welcome. Before we dive into the conversation, there is a presumption among Ugandans that Honorable Mohammed Ssegirinya as well as Honorable Alan Ssewanyana are political prisoners. In your view, do you think they are political prisoners?
Well, I would not want to go into the political side of it, but I think what motivates people to think that they are political prisoners is the manner in which the judiciary, especially the High Court in Masaka, handled their bail applications. Certainly was very troubling because the law is quite clear for sure on bail. One, bail is based on the presumption of innocence. In Article 28, Clause 3 of the Ugandan Constitution, says a person charged with a criminal offense is presumed to be innocent until a person has pleaded guilty or been proved guilty. And flowing from that, Article 23, Clause 6A, B, and C provide for when a person can be granted bail. Article 23, Clause 6A says any person charged with an offense has a right to apply for bail. A right to apply for bail.
For bail, yes.
Clause B and C give two special instances where bail now is not just a right to apply, but automatic right to be released on bail. If a person is charged with a non-capital offense, they are entitled to be released on bail after they have spent more than, should be 90 days in detention. And if a person is charged with a capital offense, after they have completed more than 180 days in detention, in a pre-trial detention, then they are also entitled to bail.
Yes.
Now, when you come to this current situation, Honorable Alan Ssewanyana and Honorable Mohammed Ssegirinya are clearly entitled now to what we call automatic bail because they have spent over 180 days in pre-trial detention.
Yes.
So right now it should not be an issue of are they entitled to bail or not. But now the problem is who is supposed to be granting them bail. That's where part of the confusion comes. But this confusion shouldn't be arising if the High Court in Masaka had followed the law on bail. There is no doubt that when you read the ruling of His Lordship, Lawrence Toyanze, it's very difficult to square his position of the law with what the proper position is. We have around three decisions of the Constitutional Court clarifying the principles to follow in granting bail. We have a whole body of bail rulings for the past almost 3 or 4 decades, explaining, for instance, that you cannot deny a person bail on the grounds that he or she is likely to interfere with witnesses. There must be evidence of that for a judge to make such a finding. You cannot simply look at somebody and say because he's a member of parliament, therefore he's likely to interfere with witnesses. That's not permitted. That is prejudging an accused person. And it is also a form of speculation, which a court of law is not permitted to indulge in. That is something which someone who is not a judge is supposed to make decisions based on the evidence before him or her. A judge cannot simply decide that by virtue of looking at this person and taking into account his position in society, he's going to interfere with witnesses. No.
Yes.
That also means you can look at an accused person and say, because of who he is, he must be guilty. In other words, already that ruling by the trial judge completely turned upside down the law on presumption of innocence, because the judge is already prejudging them by saying he thinks they're going to interfere with witnesses. The judge hasn't seen the witnesses. He has not seen the evidence which the prosecution has. So on what basis did he make that finding?
Yes.
And that's why we are where we are. Obviously, that having been said, I still think there are also a few procedural mistakes that have been made by maybe the legal teams representing these two honorable MPs.
So does that, according to your submission, that seemingly says that they actually qualify to be political prisoners? I would say that. Well,
a political prisoner is not really, it's not a legal term. It's a perception.
Yes.
And we'll have to wait and see. If the law is followed consistently and they're being denied. I understand they have one of their complaints is they have filed bail applications which the judiciary is not entertaining, has not had. There could be an element of misconduct. Maybe the judiciary needs to clarify if it is true that they filed other bail applications and the court in Masaka has chosen not to hear them and the principal judge has not intervened. Obviously, then the presumption that this is political persecution becomes very high.
Yes. So they, Honorable Mohammed Ssegirinya as well as Honorable Alan Ssewanyana were arrested on 7th September 2021, and until this day they haven't been granted bail like you talked about. So 9 months on remand, is that constitutionally right? Absolutely wrong.
Absolutely wrong. Article 20, they are right now, and Article 23, Clause 6C specifically says a person charged with a capital offense is entitled to be released on bail once they have spent over 180 days on remand, which is their case now. So it simply is a travesty of justice to have them members of parliament who we are very sure are not even going to run away because they are members of parliament. If they run away, we will have by-elections in Kawempe and much in the West. And it seems very unlikely in the circumstances. By the way, they are not the first members of parliament to be charged. As a matter of fact, I recall between 2001 and 2006, two members of parliament, I recall Honorable Regan Okumu and Philip Ochura, were also charged with murder. And they also got bail, I think, after something like 5 months, after maybe like 3 to 4 months in Luzira prison. And they went through a criminal trial for murder, and eventually they were acquitted. And I recall they were tried by, I think, retired Justice John Bosco Katusi, who eventually ruled that actually the prosecution case against them was fabricated.
So what does this say about the justice system in Uganda?
Well, there are so many things. Obviously, I think there is cause for concern that our justice system is allowing itself to be used for means that may not be its purpose.
Yes.
The whole point of having courts of law is it's where the disputes should be resolved. That means all of us, if we disagree with each other, if we fight with each other, there is an assumption that the courts of law are the referee, or they are a neutral party who is able to listen to all of us and then decide you are wrong,
yes.
you are guilty. The government is accusing you that you committed a murder here. You are saying, no, I did not. The judge's job is to say, according to the evidence I have seen, you committed this murder, or you did not commit this murder, you are innocent. That's what we expect from the judiciary. What we seem to be seeing is increasingly the judiciary is making it very hard for us to believe that they are administering justice impartially without fear or favor. The ruling obviously of His Lordship denying the MP's bail in Masaka for me is something of great concern. It's something of great concern and very unprecedented. We have had several people charged with treason, charged with terrorism, charged with all sorts of capital offense. They are routinely granted bail. The most important thing being that they should have substantial sureties so that they are not able to run away, they are able to come and stand trial. Therefore, it's very unfortunate that we should have that kind of situation. That having been said, evidently, when the High Court judge declines to grant bail, we have always known and it is really in the black and white in the law, you don't file an appeal to the Court of Appeal against that. You file a new application for bail, and maybe you request that the new application for bail is heard by a different judge. You don't file an appeal to the Court of Appeal. There are several examples. If I start with the most recent, there was this gentleman, Mr. Matthew Kanyamunyu. He had 2 bail applications denied. And later, he filed a 3rd bail application. He was only successful on his 3rd bail application. And I remember the judge who denied him bail, his lordship, Yasin Nyanzi, specifically ruled that if he applies for bail a 3rd time, they should give him an opportunity of having that application considered by another judge.
Yes.
I do not know why that has not happened here, especially with the legal team. Maybe they can also explain at some point to the public what their strategy is, but I'm very skeptical that they got their strategy right. Another example, Dr. Agre Kiyingi. I also recall he also applied for bail, I think, twice. He spent also close to 6 or 7 months in Luzira prison. He had 2 bail applications denied and was only granted bail on the 3rd attempt.
Yes. So,
unfortunately, the way the law is designed, I think it's actually wrong. It's a very terrible practice. And maybe it gives room for people who are in Parliament to think about whether our procedures of applying for bail are proper. But what I expected was when these honorable members of Parliament were denied bail, I always assumed they would apply for bail afresh and maybe request that a different judge, not his lordship Lawrence Tweyanze, hears their bail application. And only to learn that they had an appeal in the Court of Appeal against bail. Yet the law clearly says you can only file an appeal against a decision convicting you or acquitting you. So there is a mix-up of 2 things. We should not lose sight of the fact that the current predicament of these members of Parliament may also involve a bit of maybe strategic mistakes that could have been made in their representation.
Yes. So we can say this is a special case, at least for now. That is what we could say. But Councillor Jude, as a human rights lawyer, last year, both MPs, Honorable Mohamed Ssegirinya as well as Honorable Alan Ssewanyana were granted bail after spending 2 weeks on remand. But they were rearrested and they left prison on September 23rd and 26th, respectively. Now, before fresh murder charges were leveled against them, that was before fresh murder charges were leveled against them. So what would you say about this, and what does it say about the judiciary and the security system in Uganda?
I think, I do not know. You see, charging people is not a reflection on the judiciary. The judiciary is supposed to be an impartial clearing house. If charges are brought against an individual, the judiciary's job is to hear them. The problem that we have in our criminal justice system is, I think our criminal justice system is routinely abused by law enforcement, by the security agencies in particular. First of all, when a person has been charged, there is no need for them to be rearrested and charged afresh with a similar offense. All that could have happened is once they were granted bail on that offense, they could have any new charges, in most cases can even be brought before the same indictment, and it is simply amended. In any case, it did appear that all the charges were relating to allegations around murders in Masaka. So really they were not different. They were not different. They were not different in substance.
Yes.
Meaning, waiting for them to be granted bail and then new charges are brought clearly points to 2 things. It was an attempt to defeat the ability of these members of Parliament to get bail. And then, so too, it's clearly an abuse of the criminal justice system. There is no doubt about it. And it's an issue which even the Constitutional Court has ever pronounced itself on. But who is to blame for this? The blame would fall in the Directorate of Public Prosecutions that sanctions those charges, the police and CID that create those files and get those charges presented in that manner. But you cannot blame the courts, because in that case, the court's job is to receive what has been presented before it and deal with it one way or the other. And for sure, there are hundreds of people who are eligible for bail who are also in prisons all the time. It's only that when we are dealing with this unique case where we have members of Parliament, we know they can afford a very good legal representation. We know the public is watching their cases with keen attention. So we obviously, the public expects better. The members of parliament also deserve better, for sure. And we also cannot forget about the constituents who elected them to represent them in parliament. They also don't deserve to have their elected representatives being treated in this manner. So there are several interests that have to be taken into account. And therefore, it's probably that it's only prudent that the judiciary should also pay similar attention. I loved the Court of Appeal. Yes, it didn't rule in their favor. But the appeal was filed recently, and it was quickly heard. Appeals in the Court of Appeal, by the way, can even take 3 years, even 4 years. But the appeal was fast-tracked and given priority. So I do not know why the High Court cannot do the same.
Yes.
It simply is not proper. And so it rightly creates an impression of bad faith and political persecution.
Yes, it does.
So it really helps if the judiciary could see the need, especially now the principal judge, as the Court of Appeal justices also point out in their ruling. They say, well, clearly we have no powers to hear this bail application. We cannot hear an appeal against bail. The law does not provide for it. And frankly speaking, they are legally right. But they still point ahead that these people can't spend 9 months on remand. These are members of parliament. Let the principal judge, since the DPP now claims that they are ready for trial,
yes,
let's have the trials and decide one way or the other. But you cannot simply arrest people and keep them on remand for 9 months. They are elected representatives who you know should be in parliament. Somehow the system is denying them bail, and they're also being denied a trial. They should have one. If they can't have bail, let them have their day in court.
Let's briefly, I would like to pick your mind on the matter in which they were rearrested. As members of parliament, well, this can apply to any other Ugandan. The matter in which they were rearrested was not good at all after they were granted bail. Yeah,
obviously, it's like I've indicated, it's not the first time it's happening. It happened several times to Dr. Besigye and his co-accused, especially between 2005 and 2011. And the Constitutional Court eventually had enough of it and ordered the High Court to dismiss all the charges that they had been faced with on grounds that clearly their right to a fair trial had been severely compromised. And I think we are almost getting into similar territory with this situation. Because if someone applies for bail and the judge or the judiciary declines to hear, does not want to entertain the bail application, it becomes a problem. It means maybe there is there somebody threatening or intimidating the justices? Is there somebody system, manipulating the system? And if that happens, you obviously can't have a fair trial. So we are in a very, very unfamiliar territory. I for one would love these people's trial to start immediately, but at a bare minimum, what everyone who understands how the legal system expects, for heaven's sake, these individuals are eligible for bail. There's no question about it. We have all followed the rulings which were made by the judges. There was no evidence presented before the court that they are going to interfere with any witness. This is just pure speculation. They are not the first members of parliament to be charged with murder. They should be granted bail and go on with their business as they answer to their charges.
Okay, now let's talk about on 25th October 2021, the Masaka High Court judge, and that was Lawrence Ssewanyana, dismissed both MP's bail application on grounds that the two are accused of a string of capital offenses. Yes, and that attracts a maximum of a death penalty. And also, he reasoned that the MPs could flee from justice and that they were given the position in society as lawmakers that would interfere with the trial process and investigations. I think you mentioned it earlier when you're answering the first question, but how constitutional was that ruling?
No, the ruling is, frankly, the ruling offends the Constitution. First of all, it's clear that the judge has chosen to throw out of the window the presumption of innocence. Article 28, Clause 3, a person charged with a criminal offense is presumed to be innocent until proved guilty. So, the nature of the offense a person is charged with is not very relevant when they are applying for bail. It's only relevant in the context of what bail terms should be provided. Because, you know, we have two laws. The legal regime, the laws that govern bail, are provided, of course, we have the Constitution, which is the supreme law of the land. We have the Trial and Indictment Act, which governs bail in the High Court, and we have the Magistrates Courts Act. We have also got the Constitutional Court ruled that the provisions on bail in the Trial and Indictment Act and the Magistrates Courts Act should be read in strict conformity to the Constitution, and therefore the idea, for example, that bail can only be granted in exceptional circumstances, the Constitutional Court did away with it and explained that when a person applies for bail, a judge or a magistrate is free to take into account various circumstances that are presented. Is this person likely to abscond? What's the evidence? For instance, if someone has previously been given bail and has absconded, it can, of course, become a problem. You may recall there was this particular situation of this lady, or popularly called Bad Black. She was given bail by the Court of Appeal, and she jumped bail and left the country. Then later she was rearrested. At that point, they couldn't give her bail afresh. She had to go and serve her term as she was appealing, and she completed her term before her appeal could be heard. So there are those cases. If a person has jumped bail before, you could do, and that evidence is presented to the judge. A judge is not supposed to rely on the newspapers, on the media, to form views about things. No, not about the cases that is before him or her. So even the idea that these are prominent members of society, how does the judge determine that? Because they are members of parliament. Maybe that's something he can, we cannot hide that, that's obvious. But the idea that they're going to tamper with witnesses, where did the judge get that from?
Yes.
The judge is simply suggesting that if you are prominent, it means you're going to tamper with witnesses. Then maybe they're also right to say, maybe the president who appointed the judge is also tampering with him in that case. If you're going to say any prominent person in the justice system is too powerful that they cannot allow justice to be done if they are not in prison, you are sending a wrong message. The judge is throwing so many established legal principles out of the way, and it is very, very, very dangerous. Bail is handled the same way you decide whether a person is guilty or innocent. You follow the evidence and you follow the law. The law clearly says they were entitled to apply for bail. They are entitled to a presumption of innocence.
Until proven.
Once you have those two, the third thing is, if you give them bail, are they going to be able to present themselves for trial? That's all you consider. If the state thinks they are tampering with witnesses, the state must bring that evidence. I have seen the bail applications where they used to bring it. For example, maybe they say, well, when this person was arrested, or when he was in prison, he sent threats to potential witnesses. But as we speak now,
that evidence
it is very
not there.
obvious.
Yes.
Their trial hasn't started. They have not even been given pre-trial disclosure. In other words, they have not been given the sort of evidence that's going to be brought against them. So I strongly even suspect they have no clue who the potential witnesses are in their trial. So it's absolutely shocking for the judge to say they're going to tamper with the witnesses whom they probably do not even know. Because for sure the judge didn't indicate in his ruling which witness they have attempted to tamper with. If that evidence was there, maybe we could say, yeah, there is a point here. But that evidence was not given to the judge. So what we have, sadly, is a bail ruling that was based on speculation, which is very, very unfortunate. And one can only hope that it will be corrected sooner rather than later.
Now that you say that this particular ruling was not constitutional at all, my question would be, how are the courts of law getting away with this? Or even why?
No, I think there are two. This happens, one, you see, the courts of law have those internal checks. They have the Judicial Service Commission that's supposed to oversee what the judges are up to, whether they are following the law and things like that. A judge has that individual independence to make decisions without having to report to any supervisor as such. But I think why we are getting this problem is as the public is not subjecting judges and the court system to appropriate scrutiny. I also think that maybe it's time for the public to play a more active role in the manner in which these judges and magistrates are appointed. Because you are going to get judges making decisions and which we know are very problematic, and tomorrow they are promoted to the Court of Appeal, to the Supreme Court, and everyone forgets about their rulings. our elected representatives, members of parliament, are those who vet them through the appointments committee. I know it does its work in hiding, but for sure we know the names when they're being presented. But maybe we need to have more candid conversations about what our elected representatives should do. Maybe the vetting also needs to be more public and more transparent, so that if we think this magistrate once made a ruling of this kind, and now he is being considered for a judicial position as a judge, that evidence should be brought to the public domain. So checks on the judiciary can come from the public.
Okay.
The judiciary has its own inbuilt system. We can always debate whether it's working or not, but definitely the public, the media has a role to play. We need to be able to discuss and scrutinize these rulings so that it does not remain some ruling that is that's obscure and is in a court of law. Nobody knows about it apart from maybe a handful of lawyers. So it's very important for us to have these sorts of conversations.
Okay, you did mention in your submission, and you pointed out the lack of strategy from the members of parliament legal team. Now, does this explain the delayed freedom of the legislators, or there are other contributing factors?
Yeah. Well, I didn't say it's not a lack of strategy as such. I simply stated that I think they could have gotten maybe the strategy wrong. But I have not looked at the entire case, so maybe it may be a very harsh assessment. I can only comment on what I have seen. I have seen, for instance, that they filed an appeal against a bail ruling. I wouldn't have done that for sure. It was clearly not tenable, so it could have given very false hopes to the honorable members of parliament. It wasn't necessary, and it also kind of maybe may mislead the public to think that the Court of Appeal, like I've heard you people saying, that the Court of Appeal has refused to give them bail. But the Court of Appeal simply said, we don't have powers to even listen to their bail application. That's all that the Court of Appeal
Is that true?
Basically said, yeah, absolutely. Very correct as per the law. It's something very simple, nothing controversial about it. Nobody has ever been granted bail by the Court of Appeal, nobody. The only court which could probably give them a flicker of hope is the Constitutional Court. The Constitutional Court, yes, there could be some possibility. Yes. But the Court of Appeal, hearing a criminal appeal against a bail ruling, doesn't exist at all. This was their application was frankly unprecedented and quite surprising from my point of view. So, yes, there could be a temptation as well for their legal teams to want to play to the gallery. It's always a temptation when you have these kinds of cases where the media is all over and it's in the public domain. Sometimes there can be a temptation to not pay close attention to the legalities and focus more on the public opinion. It's not a very good idea in my view. Not a very good idea. It's still important that no matter what the public opinion is, an accused person should try to get a legal team that is paying close attention to the law. Because you see, the public sentiment is these people are, like you put it, are being politically persecuted. It may be true for sure. It may be true, it may not be true. We don't know. But what they need is a legal team that decides to focus on the legalities. And then they have enough politicians who wish them goodwill, who can still focus on the public opinion and the political side of things. But it's very important that they get effective legal representation, and frankly, I found it a bit surprising. This kind of strategy, I found it very, very surprising.
I do think that they actually have a remarkable legal team, but your opinion seems to differ from mine. However, moving forward in this bid for freedom for these two members of parliament, what is the way forward for them so that they don't have to spend any more months on remand and maybe to have the right to fair trial?
As the Court of Appeal directed, let's see what the principal judge does. He should also be called to account. He's the supervisor of the High Court judges. If a judge is refusing to hear a bail application, then the principal judge needs to weigh in and let the public know whether that is proper or not. In my view, it is not. So obviously, but that's assuming that indeed there are bail applications which they have since filed and which are not being heard. If that's the case, yes, the principal judge certainly needs to weigh in so we know what's going on and we understand why. What is so special about these two that they can't be, that their bail applications can't be entertained by another judge? Other people, I've given you an example, Matthew Kanyamunyu's situation. He was denied bail by Justice Ssewanyana twice, and then the third time he was granted bail by Justice Wilson Kwesiga. So for sure, no, we should not have this kind of situation. Yes. It should not be happening at all. And no matter what views we may have about the legal strategies of their team or not, this should not be happening. Because at the end of the day, the criminal justice system cannot operate just based on the abilities of the lawyers, really. Yes, as lawyers, we play an important role in the whole system. But again, there are thousands of people who cannot even afford a lawyer. What would their fate be? So the courts have to be very proactive in preserving rights and ensuring that everyone is getting a fair trial. And we need to see that happening, even for these two honorable members of parliament. Yes.
So, Councillor Jude, as we wrap up the conversation, as a human rights lawyer, what advice would you give to the legal team of Honorable Alan Ssewanyana and Honorable Mohammed Ssegirinya, so that, you know, they can ensure that they secure, you know, bail or, you know, freedom for their clients?
Yeah. Of course, it's not to give legal advice as such, but I am looking forward to new bail applications being filed, or if they were filed, I'm looking forward to their legal teams tasking the principal judge to allocate them another judge to hear their bail applications. I hope that can happen next week. I'm hoping it can happen. We need to know, and what they should tell us, we members of the public who have a strong interest in the rule of law and human rights, is, well, we applied for bail. We have requested a principal judge to allocate a judge to hear our bail application. Nothing has been done. Then at that point we'll say, oh yes, they are helpless. There is something fundamentally wrong with what's going on. But if we learn that there's no bail application that has been filed, they are pursuing an appeal to the Supreme Court, we may say, well, this is a very unfortunate situation, but maybe even the legal team needs to revisit its strategy a little bit. It may be something to think about.
Yes.
I don't want to have very harsh an assessment of the legal team's approach, but again, I think the public has a right to know what the correct procedure is. Otherwise, somebody following this trial may also eventually think the procedure they adopted is normal. It really isn't.
Yes. Okay, we'd love to get your parting shots in regard to this, you know, entire case.
Oh, well, yes, like I've indicated, I think this trial, I'm even finding it difficult calling it a trial. I'm more tempted to call it a saga involving the two members of parliament. Is a very serious dent on the judiciary, and it's very important that the judiciary, especially the important players in this, for now I think it's the principal judge, whom the Court of Appeal has requested to try to expedite the trial of these two individuals. We should not have two elected representatives of the people whose job is to pass laws being handled in a manner that clearly appears to be lawless and to be in disregard of the constitution of this country.
Yes.
We don't need this. It brings our criminal justice system into disrepute, and it also lends credence to the theory of the people who see this as political persecution. It should be the job of the judiciary to ensure that the judiciary is not used as a rubber stamp for political persecution. And therefore, it's very important that the judiciary does the right thing.
Well, thank you so much, Councillor Jude, for joining us, and, you know, for that insight. It's very much appreciated.
Okay, thank you.
Well, this has been Councillor Jude Biamukama, who is a human rights lawyer, and he has been weighing in on the case, or what he actually called the saga of Honorable Mohammed Ssegirinya of Kawempe North, as well as Honorable Alan Ssewanyana of Makinde West, who are still, you know, appealing for bail. And also, definitely, as CTV will be bringing to you all the details in regard to how this case will be unfolding. But for now, coming up is a wellness, beauty and lifestyle segment, and Sarah Apollo and Priva Elibas are on standby to bring to you hit or miss, and also the glitz and glamour at the BET Awards that happened this week. This is Sunrise at Sea. Don't blink.